Well, good morning. It's my pleasure to welcome you. I'm Glenn Cohen. I'm a professor here at the law school, and I'm also the faculty director for the Petrie-Flom Center for Health Law Policy, Biotechnology, and Bioethics. So normally we have a beautiful screen projecting, but for the first time in 14 years, hopefully it's not a bad sign, the projector went kaput. Luckily, our friends from AV are going to be setting up a portable projector during the break, but I will instead ask you to imagine the beautiful image we had here and the hashtag for this event, in case you're tweeting, which is abortion in Mexico. This is an incredibly exciting event. It's an event that we hope will stir up passion and debate, and we like debate, but the university has some guidelines as to how to keep debate productive in a way that doesn't silence anyone, but instead brings the multiplicity of voices. So I'm just going to say a word about the university's protest policy. Displaying a sign, wearing significant symbolic clothing, gesturing, standing, or otherwise protesting noiselessly is acceptable unless the protest interferes with the audience view or prevents the audience from paying attention to the speaker. Any use of signs, prolonged standing, or other activity likely to block the view of anyone should be confined to the back of the room. The audience, like the host and the speaker, must respect the right to dissent. A member of the audience or the host organization who substantially interferes with acceptable dissent is violating these guidelines in the same way as a dissenter who violates the rights of the speaker or the audience. Sure, we won't need those, but again, we do like debate, we do like dissent, we just like it such that we can still hear both sides of the discussion. So incredibly excited to have you here at Harvard Law School. First and perhaps most important thing I can tell you is that the washrooms, or the bathrooms as you say in this country, are over there, down the hallway and to the right. We have men's and women's. And we have also some gender neutral bathrooms as well. And I want to introduce the person who's really the key person behind today's event. She is amazing. I've known her for about a decade, and we're just so delighted to have her here at Harvard Law School. And that's Alicia Amin, who's the Senior Fellow, Global Health and Human Rights Project at the Petrie-Flom Center. It's a new project that she's kind of really invigorated, and this is one of the marquee events it has created. So Alicia, if you'll come up here.
Thanks, Glenn. Thanks for that generous introduction. And I also want to echo that we're absolutely thrilled to be having this event, that the justices have been able to take time out of their busy schedule during the session to share their insights on the evolution of abortion jurisprudence in Mexico, that Judge Saiho is also with us, and the other eminent speakers we have. I want to take a moment to thank the many people who made this event possible, because it was really a collective effort. And that includes, first and foremost, my colleagues at the Petrie-Flom Center, who are really, truly extraordinary. Glenn Cohen, whom you've just met, but also Christine Hutchinson-Jones and Caitlin Dowling, without whom this event would not be happening. I also want to mention Carmel Shachar, who is the executive director of the Petrie-Flom Center, and for a happy reason that she just started maternity leave, could not be here, but she was also pivotal to this event. One of our speakers today, Cristina Alonso, is not only speaking and moderating a panel, but has also agreed to help us at the last minute with translation. I'd like to thank just a few more people who are not here as well. Regina Tamés, who runs one of arguably the most important reproductive rights non-governmental organization in Mexico, and a close colleague and friend, helped with some of the judgments and background materials for me. What I hesitate to call clerks, because the Supreme Court of Justice auxiliary magistrates are really more than clerks, were fundamental to putting this event together logistically, and also to this kind of substantive content of the event. Finally, Professor Sofia Charbel at the ITAM, the Technological Institute of Mexico, really fostered and engendered the idea for this event. And we very much hope to continue to collaborate with ITAM and with Professor Charbel. Now, I want to say a minute about the event itself. This topic is very alive in the media and in political fora. Last week I was at the General Assembly where the United States led an effort to remove sexual and reproductive health services and rights, and especially focusing on abortion, from the high-level political declaration on universal health coverage, in which it was joined by Iraq and Saudi Arabia and Yemen and Hungary, and a number of other countries. That ultimately did not prevail, but it is very hotly politically contested. It's also a topic that lies on several fault lines in the law, and that's what we're going to discuss today. It causes us to question the gendered construction of the public political domain versus the realm of private morality. It causes us to look at the institutional capacity and sociological legitimacy of courts in adjudicating issues of extreme social contestation and potential backlash, and the role in a world where international and constitutional law is ever more porous, the role of supranational tribunals. It causes us to ask, when should the law defer to a biomedical narrative of when life begins, of fetal viability, of gestational age limits, of the seriousness of a medical condition that rises to the level of constitutional protection. And finally, I think it forces us to grapple with what law and society scholar Vincenzo Ferrari says, which is that this is not just a matter of courts resolving disputes, but that the law also interacts with and establishes social discourses and norms and structures institutions, including health systems. And I'm hoping that throughout the morning we'll be able to touch on a number of these fault lines, even though undoubtedly we will not be able to come to consensus.
Wonderful. Now I'm going to introduce our first speaker. One thing to note, so we have a timer here for them to look at, but one of the privileges of being a Supreme Court justice is you don't have to follow the time. You can talk as long as you want. Nobody ever cuts you off, right? Just to help them, though, for their timing and the like. So our first speaker is Justice Juan Luis González Alcántara Carranca, who holds a Doctor of Law degrees from UNAM with a specialization in public finance. He also received a master's degree in international relations from the Fletcher School of Law and Diplomacy at Tufts, and a master's degree in civil law from the University of Barcelona. The justice's career is notable for his contributions to both academia and public service. He is taught as a full law professor at numerous institutions in Mexico, including the prestigious UNAM, Ibero, CIDE, and ITAM. He continues to be an honorary researcher at the Institute of Juridical Research at the UNAM, a well-known center for the production of legal scholarship for the entire region of Latin America. He is the author of numerous books and articles, and was also a member of the drafting group of the Constitution of Mexico City. The justice has also served in various capacities as a judge. Prior to his appointment as a justice of the Supreme Court of Justice to the nation in Mexico, he served as a judge of the Superior Court of Justice of the Federal District in Mexico City, including 3 years as president of that court. The justice has sought to integrate his academic and judicial work, including through the dissemination of important classical contemporary legal scholarship and the organization of both postgraduate and continuing legal education. He also, among other things, worked for the establishment of the Alternative Justice Center, which promotes mediation, reconciliation, and arbitration, and the Human Rights Directorate in the Superior Court of Justice of Mexico City, which was among the first established in a superior court. The justice has received numerous honors, including the René Cassin Human Rights Award from the Non-Governmental Jewish Forum and the Academic Merit Distinction awarded by the Ibero-American University. Please join me in welcoming the justice.
Muy buenos días, tengan todos ustedes.
Good morning, everybody.
Para mí es un gran honor estar aquí en la Escuela de Derecho de la Universidad de Harvard.
It's a great honor for me to be at the Harvard University Law School.
Y agradecerles a ustedes su presencia, en especial a Glenn Cohen, a Alicia y a Cristina, y a todos ustedes, desde luego.
And I especially want to thank Glenn Cohen, Alicia Amin, and Christina Alonso, and everybody else for being here.
El tema que se me asignó es las batallas sobre el aborto en México y más allá.
I was asked to speak about the abortion battles in Mexico and beyond.
El aborto y su regulación es una de las discusiones que más ha dividido a la sociedad en buena parte del continente americano y en otras partes del mundo.
Abortion and its regulation is one of the arguments that has most divided societies in great part of the world and the American continent.
En esta lucha que Lawrence Tribe llama una guerra de absolutos entre vida y libertad, son pocos los países que han podido llegar a un consenso que descanse en la libertad más amplia de la mujer para terminar con un embarazo no deseado.
In this fight that Lawrence H. Tribe has called a war of absolutes between life and liberty, there are very few countries that have been able to arrive at a consensus that rests on a freedom that's a greater freedom on women's rights to end an unwanted pregnancy.
En Estados Unidos, su Suprema Corte estableció un importante precedente en el que la balanza se inclinó hacia la libertad de las mujeres desde el año de 1973.
In the United States, the Supreme Court established an important precedent in which the balance was tipped towards women's freedom in 1973.
El histórico caso Roe versus Wade resolvió por la vía jurisprudencial algunas cuestiones que, en la gran mayoría de los países del continente, continúa sin una respuesta tan contundente por parte de las cortes y a veces inexplorados.
In the historic case of Roe v. Wade, it was resolved through the jurisprudential means a few questions that the majority of countries in this continent can continue without having a response, such a firm response on the part of the courts, and in many places not even explored.
Sin embargo, la discusión, por supuesto, no está zanjada.
However, the discussion has not been resolved.
En el caso Roe, continúa polarizando a la sociedad estadounidense, quizá como ningún otro, y a pesar de que la ratio decidendi de este caso no se ha abandonado.
The case of Roe continues polarizing the American society in ways that no other issue does, despite the fact that the ratio decidendi on this case has not been abandoned.
El más alto tribunal de esta nación continúa decidiendo casos relacionados con los efectos y las implicaciones del derecho constitucional que reconoció aquel histórico fallo, el derecho de las mujeres a decidir sobre su embarazo.
The highest court in this nation continues to decide cases related to the effects and the implications of the constitutional right that recognizes that historical decision, the right of women to decide on their pregnancy.
Para contextualizar el caso mexicano, puede ser útil trazar algunas distinciones entre la experiencia estadounidense y la mexicana en el tratamiento de la jurisprudencial de esta figura.
To contextualize the Mexican case, it could be useful to lay out some distinctions between the U.S. experience and the Mexican experience on how we treat the jurisprudentiality of this figure.
Cuando se decidió Roe en el año de 1973, prácticamente todos los estados de la Unión Americana criminalizaban el aborto, estableciendo solamente algunas circunstancias que lo permitían.
When Roe was decided in 1973, almost all states in the USA criminalized abortion, establishing only a few circumstances where it could be allowed.
Como sabemos, el caso llegó a la Corte porque Jan Roe impugnó una de tales leyes en el estado de Texas que criminalizaba el aborto con la excepción de que pusiera la vida de la mujer en riesgo.
As we know, the case arrived to the courts because Jane Roe challenged one of those laws in the state of Texas.
En este contexto, la Suprema Corte se vio llamada a decidir si las mujeres tenían la libertad para tomar esta decisión y cómo no podría ser de otra manera, se apoyó la línea jurisprudencial propia que había limitado la capacidad del gobierno para interferir en ciertas decisiones personales sobre el matrimonio, la procreación y los asuntos familiares.
In this context, the Supreme Court saw that it was time to decide whether women had the freedom to make the decision, and since it couldn't be any other way, it supported the jurisprudential decision that had limited the capacity of the government to interfere in certain personal decisions on marriage, procreation, and family affairs.
Sobre esta línea, la Corte decidió que el derecho a decidir sobre su embarazo estaba protegido por el derecho fundamental a la privacidad de la mujer.
On this subject, the court decided that women had the right to decide that their pregnancy was protected by the fundamental right of women's privacy.
En el caso mexicano, prevalece una situación como la que enfrentaba Estados Unidos hace casi medio siglo.
In the Mexican case, we had a very similar situation that was as the U.S. did almost half a century ago,
En la que cada legislatura establece distintas causales para permitir el aborto.
in which each legislator establishes different causes to allow abortion.
Solamente la capital federal y muy recientemente el estado de Oaxaca no criminalizan el aborto dentro de las primeras 12 semanas del embarazo.
Only in the federal capital and very recently in the state of Oaxaca is abortion not criminalized in the first 12 weeks of pregnancy.
Así, la primera diferencia que puede trazarse es que, mientras en Estados Unidos la legalización del aborto responde a una determinación de la Corte, en México la legalización del embarazo ha venido muy lentamente desde el órgano democráticamente electo.
Therefore, the first important difference that can be seen is that while in the U.S. the legalization of abortion responds to a decision made by the court, in Mexico the legalization of pregnancy has come very slowly through a democratically elected body.
Por ello, mientras que la Corte estadounidense abrió la puerta al aborto a partir de que invalidó una prohibición, la Corte mexicana lo hizo a partir de sostener la validez de una permisión.
Therefore, while the American court opened the door to abortion through invalidating a prohibition, the Mexican court did it through sustaining the validity of a permission.
Me gustaría comenzar este foro haciendo un breve recuento de algunos momentos importantes en la batalla legal que se ha llevado a cabo en la Suprema Corte de México.
I would like to begin this forum recounting a few of the most important moments in the legal battle that have allowed for the Supreme Court of Mexico, in terms of abortion, to make emphasis on the arguments that have been used both to expand this right and also to limit it.
Haciendo un énfasis en los argumentos que se han utilizado tanto para ampliar este derecho como para limitarlo.
Emphasizing both the arguments that have been used to expand this right and also to limit it.
La primera vez que se planteó ante la Suprema Corte un caso fue en el año de 2000, cuando la capital federal decidió modificar su código penal para permitir el aborto en dos supuestos.
The first time that the Supreme Court of Mexico arrived at such a case, it was in the year 2000, when the federal capital decided to modify its penal code to allow abortion for two reasons.
Por el llamado aborto eugenésico y por causas de violación.
The so-called eugenic abortion and in cases of rape.
En los inicios de su propio desarrollo jurisprudencial sobre el tema del aborto, la Suprema Corte Mexicana decidió enfrentar los problemas jurídicos.
In the beginning of the jurisprudential development on the issue of abortion, the Mexican Supreme Court
decidió enfrentar el problema jurídico respondiendo preguntas.
decided to confront the judicial problem by answering two questions.
¿Hay un derecho a la vida expreso en la Constitución?
Is there a right to life expressed in the Constitution?
Y si lo hay, ¿cuándo comienza la protección de ese derecho?
And if there is, when does the protection begin towards this right?
La Corte respondió a estas preguntas en la acción de inconstitucionalidad 10 del 2000.
The court responded to these questions in the challenge of the action of inconstitutionality 10-2000.
Sobre la pregunta de si existe un derecho a la vida, protegido constitucionalmente, la opinión mayoritaria de la Corte declaró que nuestra Constitución reconoce el derecho a la vida.
On the question of whether or not there is a right to life that is protected by the Constitution, the majority opinion of the court declared that our Constitution recognizes the right to life
Y protege toda manifestación de vida humana, independientemente del proceso biológico en el que se encuentre.
and protects all manifestation of human life independent of the biological process in which it is.
Sobre la pregunta, ¿qué tiene que ver más cuando comienza la vida?, concluyó que la Constitución mexicana sí protege la vida humana y de igual forma protege al producto de la concepción.
On the second question, which has to do more with when does life begin, the Constitution determined that it does protect human life, and in the same way it protects the products of a conception.
En tanto que esta es una manifestación de la vida humana independientemente del proceso biológico en el que se encuentra.
Because this is a manifestation of human life independent of the biological process in which it is.
Esto es, la Corte decidió encuadrar el problema jurídico que plantea el aborto en términos de una afectación al derecho a la vida del nasciturus.
Therefore, the Mexican Supreme Court decided to frame the judicial problem that abortion in terms of an harm to the right to life of the nasciturus.
Así, es pertinente hacer notar una divergencia importante en la argumentación de ambas cortes.
It's important to note a divergence in how both courts argued this issue.
La Corte estadounidense enfrenta el caso de Roe e incluso rehusó expresamente encuadrar el problema en estos términos.
Therefore, it's important to, the U.S. Supreme Court decided to confront the case of Roe using specifically framing the problem within these terms.
Por el contrario, señaló textualmente que no era necesario resolver la difícil pregunta sobre en qué momento comienza la vida.
In contrast, it actually stated that it was not necessary to resolve the difficult question of in what moment does life begin.
Y sentó como precedente que la palabra persona a la que se concede protección constitucional en la 14ª enmienda no incluye a los no nacidos.
And it establishes precedent that the word person, which is established by constitutional protection in the 14th Amendment, does not include those who are not born.
Al sentar estas bases en la discusión, al menos en el plano jurídico, la Suprema Corte estadounidense pudo haber hecho un gran servicio a la discusión sobre los derechos reproductivos de la mujer.
By establishing these foundations in the discussion, at least in the judicial world, the U.S. Supreme Court could have done a great service in the discussion about reproductive rights of women.
Puesto que permite hacer distinciones graduales entre los intereses que están en conflicto,
Because it allows for slow distinctions between the interests that are within this conflict.
los del Estado para proteger la salud de la mujer y una vida potencial,
Those of the state to protect the life of the woman and a potential life.
y por otro lado, la autonomía de la mujer y su derecho por decidir.
And on the other hand, the autonomy of women and their right to choose.
Esta distinción fue importante en Roe porque dio lugar al esquema de los 3 trimestres.
This distinction was very important in Roe because it established the framework of the 3 trimesters,
en donde el interés del Estado se iba haciendo progresivamente más fuerte hacia el final del embarazo.
where the interests of the state grew progressively towards the end of pregnancy.
La Corte Mexicana adopta la estrategia opuesta.
Mexican courts establish the opposite strategy.
Se planteó la difícil tarea de encontrar una razón suficientemente buena para anular el derecho a la vida de una persona
The Mexican court, by adopting the opposite strategy, decided to take on the difficult task of finding a reason that was sufficiently sound to annul the right to life of a person
contra el derecho a decidir.
against the right to choose.
Finalmente, la conclusión a la que arribó el tribunal fue que la despenalización del aborto eugenésico era válida.
Finally, the conclusion at which the High Court arrived was that the depenalization of eugenic abortion was valid
Porque no era válido que el Estado le exigiera a una mujer la conducta heroica
because it was not valid for the state to demand that a woman take on heroic behavior
de continuar con un embarazo en el que el nasciturus presentara graves malformaciones que podrían en riesgo su vida.
to continue a pregnancy in which the nascituris would present serious malformations that might put her life in risk.
Sin embargo, en relación con el aborto por causas de violación, la Corte no concluyó y no obtuvo la votación necesaria de 8 votos para invalidar o validar la ley.
However, in terms of abortion because of rape, the court was not able to achieve the necessary 8 votes to validate or invalidate the law.
Por lo que la impugnación fue desestimada y no hubo un pronunciamiento sobre la cuestión.
Therefore, the decision was not reached, and there was no pronouncement on this important question.
Es decir, para el año 2000, nuestro orden constitucional reconocía el derecho a la vida de los concebidos, pero al mismo tiempo aceptaba la constitucionalidad del aborto eugenésico.
Therefore, by the year 2000, our constitutional order recognized the right to life of those who had been conceived, but at the same time accepted the constitutionality of eugenic abortion.
El segundo caso que se presentó ante la Corte Mexicana también dio como consecuencia una reforma legislativa que fue aprobada por el Congreso de la Ciudad de México en el año 2007.
The second case that was presented in the Mexican courts arrived at the legislative reform that was approved in the Mexico City Congress in the year 2007.
En esta ocasión, la reforma que se analizó tuvo por objeto, entre otras cosas, despenalizar el aborto por completo durante las 12 primeras semanas del embarazo.
This time, the reform that was analyzed had the goal, among other things, to depenalize abortion completely in the first 12 weeks of pregnancy.
Así estableció como obligación de las clínicas públicas el de proveer del servicio de aborto gratuito con un énfasis en que hubiera un consentimiento informado.
And established the obligation of public clinics to provide abortion services for free, emphasizing informed consent.
En las acciones de inconstitucionalidad 146 y 147 del 2008, la Corte tuvo que analizar si podía descriminalizar el aborto por completo.
In the acts of challenging the constitutionality 146/2000 and 147/2008, the court had to analyze if it could decriminalize abortion completely.
Sin embargo, la integración de la Corte había cambiado y contaba con 4 jueces que no habían decidido el caso en el año 2000.
However, the court had the judges on the court had actually changed, and there were 4 judges who had not been involved in the decision that was made in the year 2000.
Ello permitió que se estableciera las condiciones para un drástico cambio de criterio.
This allowed to establish the conditions for a drastic change in criteria.
A diferencia del primer caso, la mayoría de los ministros de la Corte llegaron a la conclusión de que la Constitución no protege el derecho a la vida como tal.
Different from the first case, the majority of the judges on the court reached the conclusion the Constitution does not protect the right to life.
Pero aunque así lo hiciera, no era un derecho absoluto que tuviera una preeminencia sobre otros derechos fundamentales.
And even if it did, this is not an absolute right that must be above other fundamental rights
También reconocidos por la propia Constitución.
that are also recognized by the Constitution.
Como cualquier otro, tiene el peso específico de que habría que analizarse caso por caso.
And as in other cases, it would have the specific weight that it would have to be analyzed case by case.
Pero por otra parte, analizó el derecho internacional aplicable en México.
On the other hand, it analyzed international law that is applicable in Mexico.
y concluyó que ningún tratado vinculante para México especificaba un momento especial en el que comenzara a operar la protección a la vida.
And established that there is no treaty that specifies the exact moment in which protection of life begins.
Es decir, reconsideró sobre dos aspectos fundamentales: el reconocimiento expreso al derecho a la vida y en cuándo es que comenzaba.
Therefore, it reconsidered two fundamental aspects: acknowledging the right to life and when it begins.
Como consecuencia de esta decisión quedó claro que el legislador local no tenía la obligación de criminalizar el aborto,
As a consequence from this decision, it was clear that a local legislator had no obligation to criminalize abortion.
pero así como una entidad federativa había decidido permitirlo, otras se apresuraban a cancelar las puertas a esa posibilidad, modificando sus constituciones para ponerle ciertos candados.
Therefore, just as one state had decided to allow it, others hurried to close the door to this possibility and establish certain limitations.
Apenas un año después, la Corte Mexicana comenzó a conocer de casos en los que se cuestionaba si era válido que los congresos estatales establecieran en su constitución que la vida estaba protegida desde el momento de la concepción.
Less than a year later, the Mexican court began to know of cases in which the question was asked and whether it was valid that a state Congress could establish in its constitution whether life was protected at the moment of conception.
En dos acciones inconstitucionales, dos estados de la República Mexicana, Baja California y San Luis Potosí, lo establecieron.
In two causes of action challenging the Constitution, 11-2009 and 62-2009, the Mexican court analyzed two of these cases that were coming from the Constitution of Baja California and San Luis Potosí.
Habían establecido reformas constitucionales para establecer con claridad la preeminencia del derecho a la vida como fundamento de todos los demás derechos.
Both states had reformed their constitutions to establish with clarity that the right to life was a basic right above all others,
Y que este derecho comenzaba desde el momento de la concepción del individuo.
and this right began at the moment of conception of the individual.
En ambos casos, la Corte Mexicana no alcanzó la mayoría para invalidar este tipo de normas.
In both cases, the Mexican court did not reach the majority to invalidate this type of ruling.
De nueva cuenta, la discusión sobre el derecho a la vida generaba posturas irreconciliables.
Once again, the discussion about the right to life was generating irreconcilable positions.
Los ministros que favorecían invalidar las normas partían del razonamiento de que ambas constituciones locales creaban un derecho absoluto a la vida a favor del nasciturus que no admitía balances o juicios de ponderación alguno.
The judges favored invalidating the norms that came from the reasoning that both local constitutions created an absolute right to life in favor of the nascituras that would not allow for discussion or any type of alternative judgment.
De esta manera se terminaba cancelando en contra de las mujeres la posibilidad de ejercer otros derechos constitucionales protegidos.
This led to the canceling against women of the possibility of having access to other constitutional rights.
En este pronunciamiento también encontramos ecos de la decisión de Roe.
This is very similar to the decision that was made on Roe.
En aquel caso, la opinión mayoritaria estableció que era inaceptable que el Estado de Texas adoptara la teoría sobre la vida y anulara todos los derechos en juego de una mujer embarazada.
In that case, the majority opinion established that it was unacceptable that the state of Texas take on a theory about life which would annul any other right that a pregnant woman would have access to.
Si bien en el 2009 esta no fue una posición mayoritaria, la discusión fundamental comenzaba a ampliarse en términos de los derechos que estaban en juego.
So even though in 2009 this was not the majority position, the discussion finally began to expand in terms of what are the rights that were at play.
Por ejemplo, se discutió si había una violación al derecho a la igualdad.
For example, we discussed whether this was a violation of the right to equality.
En la medida que las constituciones locales trataban igual al nasciturus y a la mujer, cuando en realidad se trataba de sujetos que por sus propias características merecían un trato diferenciado.
We discussed whether the local constitutions were treating in equal measure to the nascituras and to the woman, when in reality these were two very different subjects that needed differential treatment.
También se argumentó que existía una violación a la dignidad humana de la mujer por considerar que las reformas la despojaban de su calidad de fin en sí mismo al tratarla como un instrumento para llevar a cabo a término el nasciturus.
At the same time, we also argued that there was a violation in women's right to human dignity by considering that these reforms removed her quality of life in itself by using her as an instrument to carry to term the nascituras.
De igual manera, se discutió si privar a la mujer de la posibilidad de abortar iba en contra del derecho a la salud de la mujer.
At the same time, we also discussed whether removing women's right to have an abortion was against the right to women's health.
En tanto que no se establecía una excusa absolutoria para el caso del aborto cuando estaba en grave riesgo la salud de la madre.
As long as there was no absolute excuse when women's health was in grave danger.
Por último, y de manera destacada, surgió un argumento relacionado con la autonomía de la mujer.
And finally, in a very important moment, we began to discuss women's autonomy.
Al impedir que ésta decidiera sobre el libre esparcimiento de sus hijos, así como sobre su intimidad y la autodeterminación sobre su cuerpo.
And whether we can stop women from deciding the free spacing of their children, their intimacy, and self-determination on their own bodies.
En fin, la discusión se iba ampliando y alejándose de las consideraciones de carácter absoluto.
In conclusion, the discussion began expanding itself and moving away from absolute considerations,
que obligaron a los ministros a posicionarse a favor o en contra de la vida del producto del embarazo.
which were pushing the judges to position themselves in favor or against the life of the product of a pregnancy.
En cambio, iban poniéndose sobre la mesa consideraciones relacionadas con la multiplicidad de derechos,
We started discussing considerations related to the complexity of rights that were at play.
derechos que están en juego en cada uno de los casos del aborto y que deben de ser ponderados para solucionar los problemas concretos.
Rights that are at play in each one of the abortion cases and must be considered to be able to solve concrete problems that go further than the difficult discussion in at what moment does life begin.
Luego de esta discusión, el marco jurídico mexicano sufrió importantes cambios.
After this discussion, the Mexican legal framework began going through important changes,
que darían lugar a una nueva interpretación sobre el derecho de las mujeres a decidir.
which began to establish a new interpretation on the right of women to choose.
En particular, destaca una reforma constitucional en materia de derechos humanos del año 2011,
And in particular, I want to signal a constitutional reform that happened in terms of human rights in 2011,
y la promulgación de una ley general de víctimas en el año 2013,
and the establishment of the General Law of Victims in the year 2013,
que legaliza el aborto en casos de violación en todo el país.
that legalized abortion in cases of rape in the whole country.
Una vez más, el legislador les otorgaba a los jueces el soporte normativo para ampliar los derechos de las mujeres relacionados con su autonomía.
Once again, legislators had the normative support from the judges to expand women's rights related to their autonomy.
Lo anterior dio lugar a importantes decisiones de la Corte Mexicana en materia de aborto y en casos de violación.
This gave rise to important decisions in the Mexican court in terms of abortion in cases of rape
y en casos terapéuticos,
and in therapeutical cases,
algunos de los cuales fueron presentados por el ministro Alfredo Gutiérrez Ortiz Mena, que escucharemos más adelante.
and some of which were presented by the judge Alfredo Gutierrez Ortiz.
Muchísimas gracias.
Thank you very much, and thank you for sustaining my translation.
Muchas gracias. Entonces, pasamos a... Gracias por su paciencia.
That was wonderful. We're now going to move into a second keynote speech by Justice Alfredo Gutierrez Ortiz Mena, who holds a degree from UNAM and an LLM degree from this august institution, Harvard Law School, we're proud of it, graduate, where he also received a certificate in international taxation. He was supported in his postgraduate studies by a Fulbright Garcia Robles Foundation scholarship. The justice was appointed to the Supreme Court of Justice of the nation in 2012. Prior to that appointment, from 1995 to 2012, he practiced law at several international law firms, including Covington and Burling, Holland and Knight, and White and Case. He also served in the Ministry of Finance and was appointed by the President of Mexico as Commissioner of the Internal Revenue and Customs Service from 2008 to 2012. The justice is guided by the idea that the Mexican Constitution should be read and interpreted in accordance with international human rights law, and he has endorsed the idea that those rules that limit the scope of human rights should be interpreted as restrictively as possible. The justice also consistently analyzes cases through a gendered perspective, underscoring issues of structural inequality and the need for a consistent analytical framework in addressing cases in which gender stereotypes may be at play. We could only get him on this court at the United States. He also has authored opinions in favor of interpreting the Constitution to include protections against discrimination on the basis of sexual orientation. Please join me in welcoming the justice to the podium.
Thank you very much. Thank you, Glenn, Alicia, thank you for having me here. It's great to be back at my law school. A lot of the work I do, I can trace back to my classes here, and a lot of the professors I really enjoyed listening to. Let me begin this lecture by giving a bit of a context about abortion law in Mexico. And the quick answer is abortion law in Mexico is generally found in the penal codes of the states. Abortion law, abortion is a crime in Mexico. Since it's a crime in Mexico, it's generally legislated by the states. Mexico is like the US, has a federal system, and criminal law is legislated on a state level. There are defenses against abortion, accusations of abortion. Rape, every state has a defense, a rape defense. Although in order to assert the defense of rape, the person who suffered the rape has to present a criminal complaint in order to be able to prove that she suffered rape. That has changed now. Now we can get by with an affidavit, and the affidavit will permit a defense of rape against abortion. Risk of death, that's only in 24 of the 32 states. Risk of health, you could add that to the 24, and that would be 2 more states. Fetal deformity, that's in 16 states. And economic hardship, that's in 2 states. That's in Michoacán and Yucatan, but there's a requisite you have to meet in order to be able to argue as a defense of abortion, the crime of abortion, criminal economic hardship. You have to have 3 kids before you can offer that defense. From 2007 to 2017, there were 4,246 abortion clinics reported to the police. Those cases reported to police were generally by healthcare providers, where the women went after a back alley abortion to the health providers for help because of complications from having the abortion. 531 cases went to trial. 228 were sentenced to 1 to 5 years in prison. A defense against a charge of rape does not guarantee the right to a health clinic, to a free health clinic. It's one thing to assert the right, and it's another thing to have an affirmative right to safe access to a health clinic. Probably the most advanced state, federal entity in Mexico is the City of Mexico. As Justice González Alcántara already mentioned, abortion is legal in the first 12 weeks of pregnancy, and there is an affirmative right to free health clinics for abortion. Oaxaca, last month, just depenalized, legalized abortion. So now there are 2 states, although Oaxaca does not have an affirmative duty for the health clinics to provide access to safe and health clinics. Maybe that'll come in the future. Now, I'm not going to revisit all the cases, and besides, I could not do it with the clarity that Juan Luis González just did. But I do want to mention one, and I think it's the case in 2007, because I think it sort of set the standard for a lot of what we've seen from there on. It kind of separated what the court had said before. It did abandon the right to life doctrine that had been established by the court back in 2000. But I think the case probably did more harm than good, for one reason. It established it as a state's right. And the moment you don't, or you can't find a constitutional right to a woman, whether it be a civil liberty right or a social right, but the moment you can't find that right in the Constitution, implicitly you're saying there is no right to a woman to decide over her body. And I think implicitly that's what the court did. And I think that's why you found most of the states, or a lot of the states, quickly running to their legislatures and enacting in their state constitutions the right to life. Because if it's a state issue, then on a state level, we're going to decide. And guess what? We're going to decide it's a right to life. So we're going to take what was the 2000 doctrine of the Supreme Court, and we're going to incorporate it on our constitutions, because in 2007, the court said it's a state issue. So I think that the question is a criminalization of abortion incompatible with the human rights protected by the Constitution. The court's never answered that question. We've never even come close to answering that question. I think we are building towards answering that question, but as of today, we still have not gotten there. I think the Mexico City in 2000 was definitely the opportunity of the court to finally take that step, and we did not take that step. None of the justices in the 2007 case are sitting justices today. Now, the facts of the recent case, 1388, 2015 case. And let me just read the facts, because I think they set up nicely the case. On September 24, 2013, we'll say Jane Doe was informed that she was pregnant by staff of the National Medical Center. Her team of doctors informed her that the pregnancy was considered high risk because months earlier, she had undergone gastric bypass surgery, she was 41 years old, and was overweight. For these reasons, Jane Doe remained hospitalized from September 25th to the 28th, 2013. At that time, Jane Doe was at risk of having a miscarriage. At 15.5 weeks of gestation, a genetic amniocentesis test was administered to Jane Doe to uncover whether the fetus had any hereditary condition. The procedure involved introducing a needle to obtain amniotic fluid, so the sac containing the fetus was at risk of bursting. On October 14th, 2013, Jane Doe presented discomfort, bleeding, and contractions. She was then hospitalized again due to another threat of miscarriage. The next day, she was discharged. On October 30, 2013, Jane Doe received the results of the genetic amniocentesis, informing her that the fetus had Klinefelter syndrome. This syndrome inhibits the development of genitals at puberty, but it would not prevent the fetus from being self-sufficient. Given all these complications that put her physical and emotional health at risk, Jane Doe verbally asked the hospital doctors to terminate the pregnancy on several occasions. Jane Doe was constantly refused the procedure, so on November 6, 2013, she submitted a written request to interrupt her pregnancy. In exercise of her right to health and in light of the high-risk nature of her pregnancy, which put her at risk of her health and life because of her age and weight problem, Jane Doe submitted various documents, including a technical opinion of a doctor, a surgeon specializing in gynecology and obstetrics. The doctor detailed therein that Jane Doe had a high risk of pregnancy due to morbid obesity, which caused a higher maternal risk of diabetes and preeclampsia. At that same time, due to the gastric bypass surgery, he pointed out that Jane Doe faced the risk of suffering malnutrition, obstruction of the small intestine due to internal hernia. Consequently, the doctor recommended termination of the pregnancy. As a result of the care provided by the hospital that performed the procedure to interrupt the pregnancy, on November 19, 2013, she was hospitalized urgently in a medical unit with post-abortion puerperium mediatus. She was discharged on November 21, 2013. Finally, on November 30, 2013, Jane Doe received in the mail a reply the responsible authorities dated November 7, 2013. Her request was denied for abortion on the grounds that the fetus could be self-sufficient even if the Klinefelter syndrome. In addition, it was indicated that the Institute of Security and Social Services for State Workers is a federal health institution which is governed by the General Health Law and does not provide for the legal interruption of pregnancy. She challenged the case in court, and several procedural issues, as usually happen, came up in this abortion case. The district court dismissed the case, saying that it was moot. Why was it moot? Because she had already had an abortion at a private institution, and the only thing that an adjudication could do was order for an abortion, and since she had already had an abortion, the case was moot, so it was dismissed. On appeal, the court granted cert, and we had to first address this procedural issue. And this generally happens with abortion cases. Either the case is too ripe because you're still not there, or by the time the case gets to an adjudication, either the abortion has been performed or the child has been born. So it's the first obstacle always in an abortion case. And here the Supreme Court reversed the circuit court decision on 3 grounds. First, and this is technical, but sometimes the technical issues get you where you need to be. And she had challenged the legality of the written denial. And so, because technically it's a public hospital, there is state action from that hospital. So she had standing to challenge whether the written reply was in fact based on good law or not. And that gave us the opportunity to go beyond the issue of whether the case was moot or not moot. That was the first legal technicality. But the court also said health is a continuum. And if you're arguing health and you have an abortion because of a health right, that doesn't necessarily mean your health issues have been solved. There are consequences to the abortion. There are, it's a continuum. And whether an abortion is part of your road to getting well. It may not be the end of the diagnosis or the treatment you need to have. So it's not correct to decide that the case is moot because it's a health issue. And third, gender perspective. On its face, the procedural rules for getting to court, whether ripeness or moot, are neutral. But if you look at them from a gender perspective, and if you look at them from a gender perspective, in the case of abortion, you're denying access to court to women. And you really have to interpret those laws a different way when you're addressing issues, reproductive issues with women. So the court was adamant that interpreting the law the way the circuit court, the district court had done, created a disproportionate impact towards women and was discriminatory. So on those three grounds, the case was reversed, and we were able to study the case on its merits. And I think there were three issues in the case on its merits. The first one is abortion for health reasons a constitutionally protected right? And the court said, yes, it is a constitutionally protected right. And I think this is the first time the court has said, whether implicitly or explicitly, I think it was rather explicitly, there is a right for a woman to autonomy and decide within, coming from the perspective of a health right, the right to abortion. I think this is going to set the groundwork for a lot of cases in the future, because you're now recognizing a constitutional right to abortion grounded in Article 4 of the Constitution, which guarantees everybody a right to health. Now, this is different from Roe v. Wade, and there are historical reasons for this also. The U.S. Constitution is a constitution that has civil liberties embedded in its constitution. And so right to privacy, it's really natural if you're coming from a constitution with a history of civil liberties. You have a right to privacy, you have a right to be left alone by government, and you have a whole set of cases that builds up to a right to privacy that gets you to abortion in the way Roe v. Wade did. In Mexico, it's different. The Mexican Constitution from 1917 established social rights for the first time. It's the first constitution in the world to have social rights. So for us, it's a lot easier, or it's a lot, there's a lot more judicial background to establish the right to abortion from a health perspective. And I think that's the first big difference. We're starting to find a right for a woman to choose from a right to health rather than from a civil liberty. And this has different ramifications, which I'll get into in a second. The second question is there an affirmative duty to practice abortion for health reasons in public health clinics? And the Supreme Court said yes. All public health clinics in Mexico have an affirmative duty to assist in abortion. And I think that's a big difference in grounding the right to abortion on a health right from grounding it to a civil liberty. If it's a civil liberty, you're basically asking the state, leave me alone. I have a right to determine what I want to do with myself, with my body. If it's a health right, the state has an affirmative duty, because it's a social right, to provide services for abortion. And I think this is one of the big merits of the way it's being framed in Mexico. There are pros and cons. I'll get into it in a second. The third big issue, does abortion for public health reasons cover? What does it cover? What do you mean by health reasons? That's a very, very, very ambiguous term. Does it cover physical health? Yes. Does it cover mental health? Yes. The tricky one is, does it cover social health? And what is social health? And here, if you read the case, it gives a very, very broad definition of what social health is. And that's not by accident. That is how we are trying, or the court is trying to ground the right in the Constitution from a health perspective. So if you accept the possibility of social health, then you accept the possibility that health includes the right to live as one wishes, to live well and to live without humiliation. And that is autonomy. That is being able to decide whether you want a surgery. That is being able to decide whether you want chemotherapy. That is being able to decide whether you want an abortion. So I think the pros of this approach is that there is no state discretion. It's in the Constitution. It's in Article 4 of the Constitution as a health right. And it's obligatory, but it's not only to allow abortion, it's to affirmatively provide the means for a safe abortion in health clinics. And I think the parts that need further discussion in the court, I would say individual autonomy. Yes, this is a big step. Yes, you're grounding in the Constitution the right to abortion, but you still need a doctor to intervene, and you still need a doctor to say there is a health issue. Whether it's a social health issue or however broad you define the social, you're still not at the level of autonomous decision over one's body as a discourse. And the other thing that I think is you can criticize about the decision is that it's based on risk and it's not based on gestation period. I think that's another thing that I think we should realize, that this decision doesn't quite get us all the way to an absolute right. And I think with that, I'll finish my intervention because I've gone over the time, and thank you very much. It's a pleasure being able to talk to you. Thank you.
Now we're going to have some question and answers, and I'll invite both justices to sit up here. We'll go till 10:20. We'll cut a little bit into the break to make sure the audience can be heard. In terms of asking questions, the best way to do it is to come up here and queue up in the microphone. We'll ask you to briefly just say your name. And then the one thing I want to emphasize is that we really do want questions. And a good test about whether something is a question is whether in the first 20 words there's a question mark in it. If you get more than 20 words in without a question mark, may not be a question. Please, after you, ma'am. Let's just make sure that, do a test to make sure the microphone is on. What does that sound like? Okay. I think there's a button. We all ran for it at once.
Is it on now?
See? Now it's on. Please, go ahead.
Thank you, and thank you for the cue. My name is Susan Yano. I'm an activist in abortion access, and my question to both of you is time in the law. And I'm wondering how a right, whether it's a health right or a civil right, given that gender neutrality is so important, could be for women based on a clock, so that after the first trimester, her rights change, or after the second trimester, her rights change. And I'm wondering how you contemplate under the health law, when you think about timing and gestational age, why a person, because of their gender, could have their rights curtailed based on the clock.
Well,
one at a time is better.
I think that's a very pertinent question, and that's why I meant at the end of my describing the case that we really didn't enter that issue, and I think that's a pending issue, whether it's gestation or whether it's risk. if it's risk, you don't have an issue of time. But then again, it depends how you define health and health risk. Does it include a life choice, health? Do you have a right to say, well, this is my choice in life, and then you don't have a gestational issue? I think that's very tough, because I think there are voices for the right to life. And so I think what the Roe v. Wade did was sort of compromise and say, well, there are two values that are being confronted, right to life and right to a woman's choice. And then I think the compromise was this sliding scale that you got. I don't know where the court's going to go with that in Mexico. I think that's a pending issue. Either we go with risk or we go to some sort of gestational issue. In Mexico, probably we will have legislation in that sense in sometime in the future. Generally, when the court starts getting active, you usually see the legislature come back and respond with legislative work. So I couldn't really give you a forecast. I think it's a pending issue.
But the issue of gender, the differential rights based on gender, is that part of the discussion?
Yes, very much.
Let's just see if the other justice wants to say anything.
Buenos días.
Gracias, ya me hicieron favor de traducirme, entonces va a ser más fácil la respuesta. La respuesta es muy difícil en sí y porque tenemos un problema. ¿Y cómo resolvemos?
The answer is very difficult because we have a problem.
¿Cómo resolvemos el asunto del tiempo? El tiempo lo tenemos en contra en términos generales para tomar la decisión.
How do we solve this in terms of time? Because time is against us.
Y cuando señalábamos que hay dos estados, la capital y el estado de Oaxaca ahora,
And when we were talking about the two states, Mexico City and Oaxaca,
tenemos el problema de que si una persona de un estado, pensemos San Luis Potosí, viaja a la Ciudad de México para practicarse un aborto,
we have the problem that if somebody from, for example, San Luis Potosí travels to Mexico City to get an abortion,
vemos casos de entidades que detienen a la persona que toma un autobús con la clara intención de practicarse un aborto.
we've seen places where women are stopped on the bus because it's very clear that their intention is to go somewhere else to get an abortion.
Y tenemos entidades como Baja California en donde casi meten a la cárcel a la persona que pretende practicarse un aborto a pesar de haber sido producto de una violación.
And we have states like Baja California where women are put in jail for trying to get an abortion, even though it was in case of rape.
Desgraciadamente, nosotros sabemos que la sexualidad de los adolescentes cada vez es mayor.
We also know that the sexual behavior in adolescents is increasing. It's on the rise.
Y entonces se pide en muchas entidades la autorización del padre o tutor para practicar una interrupción del embarazo.
And parental authorization is required in many states to be able to access an abortion.
Y eso genera un conflicto de intereses entre tener que revelar a su familia que ha sido embarazada, una menor,
And that causes a conflict of interest where an adolescent girl needs to tell her parents that she's pregnant.
y también tenemos la política de algunas iglesias que tratan de impedir que estas clínicas ofrezcan el servicio del aborto.
And we also have certain churches that are trying to stop clinics from being able to provide abortion services.
Sin festejar la decisión de la Ciudad de México de proporcionar gratuitamente la pastilla del día siguiente para evitar consecuencias no deseadas,
If we take the example of Mexico City that provides emergency contraception to be able to stop unwanted pregnancies,
hay una gran resistencia en casi todas las entidades para permitirle a la mujer decidir libremente lo que quiere.
there's, in most states, are denying women the right to choose what they want to do.
Nuestro sistema de justicia es muy lento.
Our judicial system is very slow,
Entonces, a pesar de haber sido producto de una violación,
and despite being pregnant in the case of rape,
habría que probar que no fue consentida la relación
women had to prove that sexual relations hadn't been consented.
Y eso genera unos costos,
And that generates costs,
un desgaste psicológico
emotional exhaustion,
y en ocasiones hasta la pérdida del trabajo o de la posición que se tenga en la sociedad.
and some women may lose their job or the position that they have in society.
Nuestra sociedad está totalmente dividida entre quienes quieren permitir la libre determinación de la mujer
Our society is completely divided amongst those who want to ensure women's right to free determination
y aquellos que dicen que hay que proteger la vida del nasciturus.
and those who believe that we need to protect the life of the nascituras.
Mucho es producto de la ignorancia sobre la propia sexualidad
A lot comes from ignorance around the nature of sexuality
y la falta del Estado de proveer para una educación sexual y facilitar
and the lack of the state to provide sex ed.
y creemos que en ocasiones la mujer con 7, 8, 9 hijos pues no quiere uno más porque es una carga económica.
And we know that sometimes a woman that already has 8 or 9 children doesn't want more. It's a huge economic burden.
Y el Congreso actualmente, en el caso de la Cámara de Diputados, plantea la posibilidad de incluir las razones económicas como una causa justificada para interrumpir el embarazo.
And the House of Representatives is currently contemplating economic reasons as a causal for abortion.
Una de las banderas más importantes del actual gobierno
One of the most important flags of the current government
es la amnistía a las mujeres que tienen penas de cárcel por haber practicado un aborto voluntario o involuntario.
is amnesty towards women who are in jail because of an abortion, whether it was voluntary or involuntary.
Y nos parece terrible que muchísimas mujeres, no habiendo querido abortar, hubieran tenido un aborto de carácter accidental.
And we think it's awful that women who didn't intend to have an abortion had a spontaneous miscarriage.
Y entonces el que el gobierno plantee esa amnistía para esas mujeres que llevan años en la cárcel, privadas de su familia,
And that the government is providing amnesty to these women who have spent years in jail.
nos parece una aberración.
Great. Well, I think that's about all the time we have for Q&A, but there'll be more. You'll hear more from the justices after our break. We're going to take a break till 10:30, but please join me in thanking this amazing presentation. So we'll be back at 10:30.